Thank you.
Maybe just
thank you. Thank you very much.
Because you see, like you raised out, there are specific issues that she had raised. If you look at CI 65,
correct.
CI 65, which obviously Parliament conceded, has Regulation 2021. 20 has the heading, application and scope. And it is clear. Let me see.
Let me read it.
Okay, let me just help me out so that I'll build.
Okay.
Application of rules.
I brought this copy here to show all of you to read, to guide the people.
Regulation 21, quote, a commission may deviate from the application of a provision of these rules where, in the opinion of the members of the commission, strict adherence to the provision is not compatible with or is not essential to the performance of the function of the committee. Now, if you come to 21, what it describes as, what's the name? Interpretation session is clear. Now, even before that, it says, subject to these rules, the High Court Civil Procedure Rules shall apply to the provisions of a commission with the modifications that are necessary for the effective performance of the function. So, with respect, Her Ladyship, the Chief Justice, possibly if she had adverted her minds to the express provision relative to this particular, what do you call it? CI, will not have made the point that she made. Because even with CI 65, for a commission of inquiry, it is limited. Even more importantly, the powers of the commission. Now, if you look, because commissions of inquiry, practice and procedure rules 2010, CI 65, and it says, quote, in the exercise of the powers conferred on the rules of court committee by clause 2 of Article 281 of the Constitution, these rules are hereby made. So specific for commissions of inquiry. The commissions of inquiry.
Hold on, please. Says the commissions of inquiry.
No.
Are also committees of inquiry. Let's draw this. Commissions are committees, depending on what they call them.
Her Ladyship Sophia Akuffo in Ajay clarified the issues and said the commission or the committee made pursuant to Article 146 is an ad hoc committee. It is not that committee envisaged by reasons of commissions of inquiry. So I think it's important that we draw the distinction and to make the point that CI 65 is completely inapplicable. What is the precedent? When Nanado Dankwa Akufo-Addo, when the process for the removal of Charlotte Osei and the late Amadou Sule, when they first went for the meeting of the committee, chaired by His Lordship Justice Anthony Bennett, it was at the first hearing, by way of precedent, that His Lordship Justice Bennett, Agnes Doji, and the late Justice Mafo Sao, and now inquire from the lawyers, including my senior Tadiosori and co, what rules and procedures should be adopted to regulate that Article 146 proceeding, contrary to what CI 65 provided. So, Senior, with respect, let's put the matters in context. And if you put it in context, you will notice that under Nanado Dankwa Akufo-Addo for Charlotte Osei, it was the committee that set up its rules, by which time CI 65 was already in existence. It was never applied. So why are we saying that the rules should be different? Because it is Justice Gertrude Toko.
You just read, hold on. I think we have to make the education abundant for our people so they will make the judgments for themselves. You just read section Regulation 20. Regulation 20, I want to read it again. It says, a commission may deviate from the application of a provision of these rules, where in the opinion of the members of the commission, strict adherence to the provision is not compatible with or is not essential to the performance of the functions of the commission. Subject to these rules, the High Court Civil Procedure Rules 2004, CI 47, shall apply to the proceedings of a commission with the modifications that are necessary for the effective performance of the functions of the commission. I won't interpret what this means. I just read and leave it there.
Can you take it again?
It says that sub-regulation 2, subject to these rules, the High Court Civil Procedure Rules 2004, CI 47, shall apply to the proceedings of a commission with the modifications that are necessary for the effective performance of the functions of the commission. So answer whether the committee, if they decided that they are even using CI 65, whether they are entitled to use CI 65 or they are entitled to use CI 47, which we are told is what they say they want to use. Now, we need to read 21 as part of the education. Regulation 21 says, in these rules, unless the context otherwise requires, chairperson includes a sole commissioner appointed under Clause 2 of Article 278 of the Constitution. Hassan?
Yes.
Article 278 is not Article 146. Now, here again, it says commission means a commission appointed under Clause 1 of Article 278 of this Constitution, not under Article 146.
Yeah.
Go on.
I think I've made that.
Just education.
No, so just what it means is that CI 65 relates to a commission appointed under Article 278. Nothing more, nothing else. Question: the Poiman-led committee, is it a committee appointed under Article 278? No.
You see, now the second issue, which was the first, not recognizing his lawyer.
Okay, so that I can deal with that issue quickly. The first day, the lawyer that appeared for her was Kwabna Kusi. So when Kwabna appeared, the committee members had no idea that this is your name lawyer because she herself had not come yet. But subsequently, she had been appearing with my senior Ayuko Otu, and the committee had recognized as such. So
was it fair?
Yes.
That a lawyer comes to say, I represent the Chief Justice. Please, no mean person. Chief Justice. And then you say, we won't recognize you because she's not here to confirm that you are actually his lawyer, her lawyer.
No, senior, with respect.
I'm coming to you. Hold on.
You see,
hold on.
There's a recent Supreme Court decision on this.
Legal representation.
This Supreme Court.
Oh, please, senior. There's a legal representation for no mean a person like the suspended CJ. At least for the record. You notice that for our cases in court, the plaintiffs are first named before legal representation. The reasoning is simple, so that the plaintiff or the party or its representative can actually confirm whether it is you who has been authorized to represent the person or not. At the material moment, that information, in fact, he had gone to make an inquiry because just around that time, they were filing processes at the court just to make an inquiry for an adjournment. Then the court said, who are you? I mean, and subsequently, with respect, senior, the substantive matter led by my senior Ayuko Otu, the committee had given her all the privileges.
What do you say? What do you say to the question that giving the press conference?
But he knows everything.
What do you say?
Who brought it up?
So I'm coming to you right now. What do you say to the defense by, as I mentioned, people like Frank Davis and Dana Sonobadapa, that her rights, human rights, trumps Article 146 Clause 8, even though 146 Clause 8 says the proceedings must be confidential, in secret. When her human rights are violated, she's allowed to come to the public and talk to them.
Which right are they asserting? Which right of hers are they asserting? First of all, she makes a proposition much earlier that, for instance, she has a right to even waive the constitutional in-camera hearing. First of all, the constitutional provision is imperative, mandatory. It's a shall. when SHA is used, how do you waive it? There's no waiver.
You are doing it to protect her, and she says, I don't need it. Let the public follow the process.
The framers of the Constitution didn't envisage that for her. And I'll tell you this. If you recall, the Ghana Bar Association in 1995, wanting to circumvent this constitutional provision,
93, 95.
Yeah, 93, 90, sorry, decided to use a writ action to circumvent this constitutional provision by putting in their pleadings the ground for removal of Aban. Look at the manner in which Justice Pega and Ajabe said, first of all, an association of lawyers, the creme de la creme of our society, should know better and not invite the court to engage in obvious illegality. Most importantly, His Lordship Justice Pega had these words. He said, look, the in-camera proceedings is to preserve the judiciary itself. Because imagine a situation where you bring cameramen to come and video the proceeding, and it turns out that the person is not guilty, as in the pleadings. However, you know what lawyers do under cross-examination? They can mischievously ask a question, knowing that the question will be disallowed, by which time they are poisoning the minds of people. All these antics are deployed in proceedings that are aired. So to protect the sanctity, have it in camera. The framers of the Constitution didn't put this provision because of one person.
Her point is that
it's to safeguard all
her point
of
is that
yes.
if the issues are matters so serious about national security and so on, then you can keep it secret. But this one, she has looked at the petitions, and these are just frivolous stuff. So let the whole world enjoy it.
Senior, hold on. Senior, I beg you. No, Senior, let me
wait. It is Senyor's turn. I'm coming to Senyor after him.
So, Senior, if you look in Article 146, the wording used, it says shall, without exception. It didn't say when the matters for the removal or the grounds borders on national security, have it in camera. No exception. Where is she creating those exceptions from? Look,
but you apply reasonable mind to it. The Constitution may not have to say it.
You see,
but reasonably we can tell that if the matter is not any serious matter, why should we do it in camera?
One provision that has received enormous judicial pronouncement is Article 146. The ins and outs of it all have been litigated in our courts.
No.
Please.
146, it has not been really litigated like
the
that.
nature of the issue that she raises.
Yes.
First of all, Ajechum resolved the matter. Plain. Much earlier, 25 years ago, the Supreme Court in Ghana Bar Association and Attorney General resolved the matter. Ajechum did. And all the subsequent decisions, Derry also did the same thing. So the whole idea that new set of rules...
Can't we have a departure?
Exactly.
Because it's not serving as well.
But you see,
what is not serving as well?
No.
The HKC Prempeh Committee is still working. My senior here, he's even had another platform, Parliament. They'll be meeting members of Parliament. We can approach the senior Professor HKC Prempeh Committee and say, look, having tried this Article 146 provision for 32 years, we are tired of it. Amend it. Said that proceedings involving Superior Court judges should be held in camera. But you see, Justice Pega said something, which I think it goes beyond today. He said, look, can you imagine a day when justices of the Superior Courts, their removal processes is being telecasted? It goes against good conscience. Timeless words. Timeless. So where from this invitation?
If you have done wrong, let the whole world know it.
What about if you have not? And I just
let the whole world know it again.
Because the process can exonerate you.
Yes.
Okay. Now hold on, all of you, hold on quietly, please.
For starters, I don't even know. I don't know what business.
I'm not holding you to anything.